All right, welcome back to the Sandler Law Podcast. My name is Theodore, or Tuvia Sandler. I'm the managing partner of Sandler Law, a civil litigation firm in Miami specializing in commercial litigation, creditors' rights, and commercial collections. Today I'm joined by Dan Gielchinsky, and I'll let Dan do a little intro.
Thank you, Tuvia. Let me just say it's such a pleasure and honor to be here on your podcast. My name is Dan Gielchinsky. I am the founding partner of DGIM Law. We are a full-service business law firm in Aventura, Florida, and my specialty areas are business litigation and commercial bankruptcies.
All right, very cool. Thanks again for joining. So what I wanted to talk about today is spotting bankruptcy fraud. Both of us work in the bankruptcy space. I do a lot of creditor reps. I think you do too. It sounds like you do some debtor work as well. So I think in particular, Chapter 7, especially for businesses, is very misunderstood, even amongst lawyers, but especially out in the big world. So just to talk, maybe just give us a brief overview of what a Chapter 7 is for a business versus what it is for an individual.
Sure. Thank you for that. So a Chapter 7 for an individual, most of the time, is the individual saying, I need a fresh start. I need a discharge. I've had a medical situation, God forbid, or I've lost my job and I've accumulated credit card debts and so forth, and can't pay them. And I need to go into bankruptcy and be rid of those debts, come out of bankruptcy with what's called a fresh start for the honest debtor, which is a discharge of their debts. And now they come out clean, so to speak. Their credit is certainly affected, but they don't owe the money to those creditors any longer, and they can move on with their lives. Conversely, a company Chapter 7 it's a liquidation. It's the company basically saying, I'm putting the keys in the door and I'm done and I'm shutting this business down. And there's no hope for reorganization. We are through. The issue you encounter with corporate Chapter 7s, first of all, there's no such thing as a discharge of a corporate debtor. But the bigger picture issue is anytime you put a company, especially a small business, into a Chapter 7 liquidation, you're going to have an unhappy client because a trustee will invariably be appointed, and trustees only make money one way, by finding assets. The assets that they're going to look to are the directors and officers of the company that's now in bankruptcy, and they're going to do an analysis of whether the directors and officers or owners received perquisites, things like tuitions that might have gotten paid through the company, charitable donations that might have been paid through the company, synagogue or church memberships that may have been paid through the company, a second car that may have been paid through the company, salaries that a trustee may argue were disproportionate to the needs of a failing small business, or distributions that may be out of line with what you would typically expect to see in a small company setting. And these are all arguments that a trustee is going to make, and understand that although they're arguments, they cost money to defend, and invariably the officers, directors, owners of that company are going to write a check. And they're going to look to you, the attorney who put them into Chapter 7 bankruptcy in the first place, and say, why did you get me in this mess? So by and large, there is very little reason to put a company into a Chapter 7 bankruptcy.
So, and just to touch on that a little more, meaning, right, a trustee is appointed, and that's by right. There's no escaping a trustee when you're putting it into a 7. By default, that's what you're doing. You're turning the company over to a trustee.
Exactly right. The United States Department of Justice runs the trustee program. There's various regional trustees, and just automatically a trustee will be appointed to take a look at the case.
And those trustees are panel trustees, meaning they're not employees of the government. They only make money. They make a nominal amount for taking a case, but for them to really make money, they have to find an asset to recover it for the estate, the bankruptcy estate, and then distribute to creditors. And they take a commission. It varies by how much they recover. So, kind of just to put a point on what you're saying is the trustee immediately needs to look for assets. So if you have a company with no assets or, not failing, there's no reason the natural place to look for a trustee is the principals.
Right.
Yeah.
100% of the time.
Yeah. Okay. So, and you're speaking more from the side of a debtor, a good faith debtor, a good faith debtor attorney, but looking from the creditor side. And, in my view, when I hear, a corporate Chapter 7, particularly a small company, by default, I basically assume it's bad faith, precisely for the reasons you've said. And, so can you tell us more a little from the creditor side? What do you look for as far as whether this is a real bankruptcy or a bad faith bankruptcy?
Sure. Just like you, if I see a corporate Chapter 7, I'm immediately skeptical. Because, as I said before, from a debtor perspective, why would you ever put a company into a Chapter 7 bankruptcy? There's other mechanisms under state law for winding down a company, or you could just take the lazy route, file a final tax return for the year in question, and sometime in the following year, file a certificate of dissolution with the Secretary of State, and see if any judgment creditors want to pursue their lawsuits and sue what they do. But they're essentially getting a judgment against something that has nothing. So now, from a creditor's perspective, I'm saying, why did they put this into a corporate Chapter 7? Now, there are exceptions, but by and large, what I'm looking at from a creditor perspective is you'll see like no assets. You'll see $600 of inventory or $300 of inventory, $16 in the bank account or an overdrawn bank account. You'll see perhaps corporate affiliates that were owned by the corporate debtor, but no disclosure of what those companies did or if they ever had assets or inventory. But you'll see lots and lots of claims. You'll see lots and lots of claims listed. They borrowed from here, they borrowed from there, they did 16 merchant cash advances. They have debts to suppliers. They have debts to the trucking company that brings the suppliers to the warehouse. They have debts to the warehouse landlord and so forth and so on. So you say to yourself, well, there was all this volume of activity on the one side where they were spending money. And on the other side, there's like no assets. So did they really just run this thing down to the ground, down to the very last nickel in the bank account and then file Chapter 7? Or is something else going on?
Right, exactly. And so I think you and I probably are a little jaded. We're in Miami, and fraud capital of the world. So it probably goes
Yeah.
on here more than it goes on elsewhere. But that's exactly the point. I think also out in the big world, people don't realize that you're not obligated to wind down a company through judicial process. You can just forget about it and let it go. So the only reason to put it into a 7 is you have lots of creditors, you have some assets, but it's just not your thing to kind of administer this company anymore. So you hand it over to a trustee. Short of that, there's no reason to put it in. So I think going back to what you said, if there are creditors and there are real assets out there, like the company has receivables, substantial receivables that a trustee would go after and make distributions, that would be a reason to put it in. But again, that's very rare in these mom and pop shops, the small cases, and more often than not, it's being put in for other reasons. And to explain a little more, so what would those reasons be? Why would someone put it in to a 7 if there was no real liquidation purpose?
It's like a fake automatic stay. So when you put a person or a company into bankruptcy under Title 11 USC 362 of the Bankruptcy Code, there's an automatic stay that goes into place. It says that all actions against the debtor, that's the entity or person that's filed bankruptcy, are now on hold, essentially. So usually there's lots of litigation pending against this company, and the principal of the company probably perpetrated a fraud and needs some time and runway to get assets out of wherever they are into somewhere that that person hopes is safe from the reach of creditors. So they'll hit the brakes essentially. They'll file a Chapter 7, a corporate Chapter 7, stay all that litigation, and now they know they've got a few months until somebody figures out kind of what's gone on, and by that time they may have disappeared. The assets may have disappeared. People are overseas. That's typically that's one of the primary reasons, I should say, in South Florida why someone would file a corporate Chapter 7. Essentially, there is a fraud going on, and they need a mechanism to hit the brakes and slow things down while they do whatever they do to exit from their scheme.
Yeah, exactly, and that's what I've seen as well. And another point I think is misunderstood there is if there is pending litigation against the principal directly, there is no stay. So meaning a stay for the corporation does not automatically stay the individual. So oftentimes I've seen this, that a person will put their company in and there's already litigation pending against the person and they've done nothing because you can just keep going after the individual. So it's a complete waste of time and money from the debtor's perspective. I'm sure you've seen that as well.
I have, but I've also seen instances where the state court judge sees a suggestion of bankruptcy get filed. That's the pleading that gets filed in the state court or federal court case that's pending that says, "Hey, there's a bankruptcy that's been filed." And that judge's clerk isn't looking to see who filed bankruptcy. Maybe there's 5 defendants and only one defendant filed bankruptcy, but they see a suggestion of bankruptcy. And they may stay the case entirely and say, go get me a bankruptcy court order that tells me what I'm allowed to do. And that'll typically buy everyone involved on the defendant side slash debtor side a good 4 to 6 weeks until you can proceed with your litigation against the non-debtor entities, meaning the entities that didn't file bankruptcy.
Yeah, yeah, exactly. I've seen that. So yeah, even though it's not really correct, state courts
Right.
do that. And if nothing else, it makes the creditors spin their wheels in bankruptcy court getting an order saying it doesn't apply to the individuals.
Another road bump on the road to recovery, if there is one.
The long road to recovery. Yes.
Yeah.
So all right, so let's say you're representing a creditor, you get into this case, all of a sudden there's a Chapter 7 bankruptcy, you see right away it's nonsense, it's bad faith. So how do you attack it?
Sure. So there are several procedural mechanisms by which to attack a Chapter 7 that may have been filed in bad faith or that's really just hiding a fraud. The most commonly used procedure would be called the motion to dismiss, where you're telling the bankruptcy court, hey, there's something really wrong going on, and this is a bad faith case. It needs to be dismissed. It shouldn't be in bankruptcy court. Most of the time, a bankruptcy judge will hold at least two hearings on that, a preliminary hearing, a shorter hearing where they're fleshing out the issues, and then schedule further down the road. And we're talking 3-4 months down the road, what's called an evidentiary hearing, where the bankruptcy court is going to take evidence on the issues that are being alleged and allow people to testify and move documents and evidence and so forth. And just gearing up for that evidentiary hearing is not a cheap exercise. We're talking about taking depositions, getting your hands on documents, issuing discovery requests, finding out what witnesses are going to say, preparing for the evidentiary hearing. If you just look at the orders that get entered on evidentiary hearings, it's like a mini trial. It is a mini trial. Some of the other options that you have are conduct discovery within the bankruptcy, issue a subpoena, start conducting discovery of the debtor or of other entities, other parties that may have been involved. Or you can file what's called an adversary proceeding, which is a lawsuit within bankruptcy court. It runs under the main bankruptcy case. It's assigned its own case number, but it's essentially a lawsuit within the bankruptcy. All of these are expensive. They're all mechanisms that can be used to delay creditors from achieving what it is they hope to do, which is ultimately collect money.
Yeah, and just to be clear, I think the motion to dismiss, I would say, is probably the most direct. Just tank the whole thing, tell the court it should be thrown out. But like you said, it can be very expensive and time consuming, and it's not like even if you prevail and the motion is granted, all that happens is you go back to state court and pick up where you left off.
Right.
It's not like, oh, okay, I win, right? So it can definitely be a big hassle for creditors. And just to touch a little more on the discovery route and adversary proceedings, so the adversary you would bring, so we're talking about a corporate Chapter 7 here. So the adversary, you would bring it against the principals, or what would the adversary look like?
You could bring one against the principals, but you might be better off with the motion to dismiss and then continuing your state court litigation. You could also bring one to determine that certain assets that are claimed to be assets of the estate are not assets of the estate. And if you win on those grounds, you can continue to pursue the assets that you claim were not properly bankruptcy assets of the bankruptcy estate. So those assets are sort of out of the reach of that bankruptcy trustee. That's not as commonly used, but it's a mechanism that can be used. But there's a variety of adversary proceedings that can be brought. Each of them has their own nuances and are very kind of case specific.
Like that latter one, that would be kind of specific to a creditor who has, provided tactile goods, so you have a lien on them, something like that. But
Right.
yeah, but if you're just a trade creditor, they owe you money, right? You wouldn't really have that option.
No.
Yeah. All right. So how do you kind of weigh it? Meaning there is another route, which is just do nothing.
Right. Right. And it happens, as we touched on before, a trustee will be appointed. And the trustee only makes money if the trustee recovers assets. Now, those assets are being recovered in theory for the benefit of the creditors, for the benefit of the estate. But the trustee gets paid first, and the trustee and his or her professionals, meaning accountants and lawyers, they're getting paid first, or else no one's going to do this kind of work. And the tax man is always getting paid first. So you need to sort of counsel your client and give some consideration to if a trustee stays in place, what are the likely outcomes? Theoretically, a trustee will go out and investigate what claims exist against directors and officers, what assets exist, what claims exist against people who receive payment, for instance, within 90 days of filing the bankruptcy. That's an asset that can be brought in. What about transfers that were made within 2 years of filing the bankruptcy that didn't have consideration or weren't appropriately made? Those are assets that can be brought in. So the trustees, what's called long arm powers, are broader or greater than what your typical creditor's powers are. So you may decide to let the trustee remain in place, understanding that if and when the trustee recovers assets, people who are getting paid first are the trustee and its professionals, then the taxman. And then, in ranking order, maybe there's a secured creditor that's going to go ahead of a trade creditor. And then when you're down into the unsecured creditors, the trade creditors, who are most commonly impacted by these types of situations, they're only going to get a distribution pari passu to the amount of their claim. So they're going to share in a distribution along with the other creditors. It might not be the worst outcome, meaning that client of yours is not going to get 100 cents on the dollar. There's no circumstance where you're going to get 100 cents on the dollar. But something's better than nothing. And that's the cost benefit analysis that you need to sort of make with your client in understanding we're going to try to get out from under this bankruptcy, or we're going to let the trustee do his or her thing, collect assets, and ultimately make a distribution.
Yeah. And, the biggest benefit to that is you don't have to bill your client anymore. Yeah.
Right?
Yeah. Versus the first routes can be exorbitantly expensive.
Very, very expensive. And, where does it get you? What is ultimately the road to recovery? That's the big question to ask, is what is the pathway to recovery? If you don't have a clear pathway to recovery, you may be better off letting a trustee do its thing and try to find assets.
Yeah. So I think one thing we've discussed in the past is there are cases where you're the sole creditor, or the only real creditor, and there are only some nominal other creditors. So in those circumstances, I think that might be the case where you tell the client, let's go for it, you're the only creditor here anyway.
Right.
But if there are lots of creditors, then I think then it becomes more logical and reasonable just to sit waiting on the trustee.
Right.
But to be clear, have you ever seen a trustee in one of these Chapter 7s move to dismiss? Because they have no real incentive to do it, right? They don't get paid for dismissing cases. So have you ever seen that, or they just let it
No,
die? Yeah.
they just, if there's nothing there, they just let it go. But the trustees, they're typically looking for something. I've never seen a trustee take that position. They'll usually let some other party take that position if that's what's to be done, because the trustee gets nothing out of, the case being dismissed.
Yeah. And if a trustee does do that, so they'll issue a report of no assets, no distributions. The court ostensibly is supposed to close the case, shortly thereafter. I have seen down here, I've seen some judges act very quickly because they know the game down here. In other jurisdictions, other districts, I've seen it take a long time for the courts to close it. So, at that point, if the trustee says there's nothing here, it's kind of up to the judge, how quickly they move as far as closing the case.
Right. The judge may be waiting to hear from other parties or not. But just this morning, I got a notice of a case closure in a corporate matter, and the matter was so open for so long, I'd forgotten about it. And the trustee must have filed the report of no distribution, no assets, a year ago. I
Yeah.
mean, close to a year ago. I literally forgot about the case, and today I got the email saying the judge had closed the case.
Yeah, so that can be, I guess, another problem of waiting on the trustee is because if they just throw up their hands, then you're kind of just waiting on the judge and no way to tell when the judge is going to close it.
You're at the mercy of the judicial system.
Yeah. All right. So another thing, I'm interested in bankruptcy forum shopping, which just to kind of detail what that is that it's very easy this day and age for a company to file in just about any jurisdiction it wants. The venue statute in the bankruptcy code is very liberal, particularly for big companies. As long as you do business in a district, basically you can file there. So have you ever seen that in a Chapter 7? One of these small companies, have you ever seen them file a Chapter 7 for the purpose of moving venue or trying to escape an aggressive creditor?
Yeah, perfect example of that. Um, the scenario is as follows. A gentleman through his company was going to ostensibly run a Pesach program in Miami. So The customers are all people from up north, New York, New Jersey, Connecticut, Pennsylvania, Baltimore,
Sorry,
and they're
just to interrupt. So Pesach, your Passover program. Just want to make it, for anybody listening.
right. So a Passover program is you come down with your family to a place that has nice weather, like South Florida or Arizona or Puerto Rico, or a cruise destination, and all the food is there. You don't have to do anything to set up for the holiday or to clean your house or follow any of the Passover related rituals and laws. They make it really easy for you. You stay at a very nice hotel, and the food is there, and everything's set up for you. And these are expensive programs. These programs can start at 10, 15,000 per person. And families are coming down here. Big families are coming to these programs. So people are spending 100, 120, $150,000 on these programs, and that's their vacation for the year. This is a big deal. In the case in question, the gentleman through his company had was ostensibly going to run a Passover program in Miami, and all his customers were up north. The program did not go as planned. Financially, he just couldn't get it together. And he was taking credit card charges that he shouldn't have taken and moving monies around in a manner that he shouldn't have been moving. And someone definitely could have made a very good claim that he had committed a fraud, because by the time it was clear to him that this program was unlikely to succeed, he continued to take people's deposits and run credit cards and do things that probably shouldn't have been done. He spoke to some very wise counsel in New Jersey, where he lived half the year, and those attorneys told him, "You do not want to file this case in New Jersey because all of your creditors, all of your affected customers are here in New Jersey or in this region. So since you live half the time in Florida, file your case down in the Southern District of Florida," which is what he did. He filed for bankruptcy in the Southern District of Florida on the hopes that none of the creditors would go through the motions of actually hiring Florida bankruptcy counsel to represent them. And that's exactly what happened, with one exception, with one creditor exception, someone who hired a cousin or a niece or nephew who's a lawyer who didn't even know what they were doing. They were like a white collar criminal defense lawyer, had no clue what to do in bankruptcy court. Nobody hired a bankruptcy lawyer in Florida to deal with it because just the dollar amounts in question didn't really make sense. And it may not have happened under other circumstances, but the company got through bankruptcy, the gentleman got his discharge, and that was the end of it.
Yeah, it's interesting. Because the classic kind of bankruptcy forum shop that is talked about is when big companies file. Like the really popular one now is Southern District of Texas. There's also District of Delaware. A lot of companies have no business in these states, but these huge companies will file there. One of the pernicious problems in my practice, at least, is representing relatively smaller size creditors. Is this problem that if the bankruptcy were filed in their state, their district, they have a lawyer they can call and go into the bankruptcy fight a little bit, and if he can't do it, he can refer out to somebody he knows. But when it gets filed somewhere else, they're not going to go hire counsel in Texas or Delaware. So I mean, it sounds like that's exactly what happened in your case.
Right.
Yeah. All right. So I think we covered what we wanted to, but maybe just a little war story here. What would you, in your experience, what's the most egregious bad faith filing you've seen, and what was your greatest success?
Sure. So on the bad faith front, I represented a creditor. It was a bank, or it was a private lender that had a mortgage, trying to foreclose. And the debtor had filed, by the time I got the case, I got the 11th bankruptcy that this debtor had filed. So it was husband and wife. The husband would go and file in New Jersey, and then the case would get dismissed. And then a few months later, file again in New Jersey, or the wife would file. Then the husband would file. Then the wife would file, and it would go back and forth because they were both signatories to the note. So automatically, the case would get stayed. And then after the New Jersey court told them don't file here again, they started filing in New York and in other districts that they claimed to have ties to. And each time, the creditor had to go through the motions of getting the case thrown out. So now I get case number 11, and I said, I need a order barring any filings by both of these people nationwide, for
And
filing bankruptcy.
just to be clear, when you say filings, you mean there were 11 separate bankruptcy petitions starting new bankruptcies.
Right. I
Yes.
have the 11th here. Right. It was incredible. Now, the case was pending in the Middle District of Florida, where I'm admitted and I practice, but I knew I was going to need a little something extra. So I called a friend in the Middle District with a fairly significant law firm, big bankruptcy presence, and I said, this case is pending in front of this judge. Who is the law clerk or last year's law clerk to that judge? And as luck would have it, that law firm had hired the judge's former law clerk, the last year's law clerk. And I said, that's who I want. I'll do the papers. You'll be my local counsel. I want that law clerk to argue the motion. And she went in, she argued the motion. And sure enough, I got what I wanted. And I got a ban nationally on husband and wife from filing bankruptcy again, nationally. And that allowed my client, of course, to go ahead and foreclose its mortgage. But what complete chutzpah it takes for someone to file 11 bankruptcies to stave off a creditor, all the while living in a luxury condo in Bell Harbor.
Yeah, and they were never actually held to account for. In other words, you ended up foreclosing, but they never got sanctioned, or the attorneys didn't get sanctioned. Yeah,
Correct.
yeah, it's amazing what goes on. Unfortunately, that is kind of the nature of it for creditor side.
Right.
Um, and that's where
In
things are.
terms of the wins column, the biggest win I would say is a case I participated in called Whitehall Jewelers. It was a national retailer of jewelry. They used to be in all the big shopping malls. They filed their case in Delaware, as many companies do, as you alluded to, many large companies do. Uh, and I had a group of vendors who had consigned goods, diamonds, basically diamonds and loose stones that they had given on consignment basis to Whitehall. Some had great consignment documents, others did not. The people who my firm had done documents for had perfect consignment agreements and UCC filings and such, everything, indicating a perfected security interest in those diamonds and stones. We banded together, my group banded together with a few other New York-based diamond groups because all the, wholesale diamond jewelers are basically on 47th Street in Manhattan. So we banded together with a few others and we hired Delaware counsel as we needed to. And we ultimately got a decision from the Delaware Bankruptcy Court that the goods, the consigned goods that Whitehall wanted to sell at a very significant discount, basically at a going out of business sale, were not property of the state and could not be sold at these cut rate prices at a going out of business sale. And just, that result was weeks and weeks and weeks of consistent effort and coordination and strategy and meetings, but ultimately it paid off and our clients got their goods back. They were very happy with that outcome.
Yeah, and that was a Delaware case, so you had to go get local counsel.
In Delaware, right?
Yeah.
Yep.
All right, very cool. That wraps it up for me. Anything you want to add, or?
No, I really appreciate the opportunity to be on this podcast. These are evolving and challenging areas of law, so I think it's good that we talk about them and educate people on them. But definitely get experienced bankruptcy counsel when the need arises, because these are nuanced areas of law, and I've seen state court practitioners kind of wander into bankruptcy court and just not get effective results because this is complicated stuff, and you've got to know what you're doing.
Yeah, no, yeah, I agree with you. And I will say it can be terribly frustrating when you represent a creditor, but at the same time, at least I find it a lot of fun going in and fighting these, oftentimes bad faith cases.
Definitely.
So yeah, definitely gonna be some fun. All right, so Dan, thank you for your time. If people want to check out your firm, where can they visit?
www.dgimlaw.com or on LinkedIn, Instagram, and Facebook. Our tag is DGIM, and you'll find us on socials.
All right, very cool. And my firm is sandlerlawpa.com, and I'm on YouTube now under the handle Sandler_law. All right, thank you, and that concludes the episode.